All right. Well, let me read from Henley because you read a certain portion of Henley, but there's more to Henley, and it says criminal negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness, in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions. 14231. To be convicted of involuntary manslaughter, a defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else. The SAG guidelines that they don't completely rely on, and I think you said that they rely. If you said completely, they rely on them in part, and they're saying that as an actor, he, despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone.
Boom.
And there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to. So I'm curious as to how you have limited it to he has no knowledge because he got to rely on his armorer, he got to rely on David Halls, and you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements. And that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, Murrieta, which you rely on very heavily, it says, State versus Murrieta. Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Murrieta in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide. So to me, and you did acknowledge that they have additional facts, and under the case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the core of whether the jury believes your facts about the armor and David Halls and that he had every reason to be able to rely on them, and the state's alleged facts that he was a producer, he knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false. I'm just wondering how you're reconciling these things.
Let me take a stab at that, Your Honor, and let me give you the short answer and then the slightly longer answer from both case law and the record. The short answer is add up all the facts that they say are disputed. Assume they win those. It still doesn't meet the legal elements of the offense. So you can imagine even.
So, folks, because we're behind a bit, I'm going to move it up to 1.25 speed. I should have done this earlier. My apologies. But that's why people will sound like they're talking faster, because they are, because of me.
It's easier cases than this, where something ridiculous. There's a murder. there's a murder charge, but the person's not dead. And no matter what else is disputed, they're obviously not going to be able to prove a murder charge if the person's not dead. It doesn't matter if there's disputed facts. In this case, and let me pick up on Henley. Your Honor quoted the carryover paragraph from pages 107 to 108 in the Pacific Reporter. The very next sentence, the first full paragraph on page 108, gives the standard that's at the heart of our motion. It says, our case law has long interpreted the requirement of subjective knowledge into the the requirement of subjective knowledge into the showing of criminal negligence required by our involuntary manslaughter statute. Later in the same paragraph, it says criminal negligence in the context of involuntary manslaughter requires subjective knowledge by the defendant of the danger or risk. So the parts that Your Honor quoted are the model instruction. We don't take issue with any of that. They may also have to prove objective knowledge, which is the should have known standard. But the subjective component, whether it's an independent component or part of what willful disregard and conscious disregard means in this context, it's clearly a requirement of the statute. I don't hear the state to disagree with this point. I mean, they can read the case just as well as anybody, and I don't hear them to disagree that subjective knowledge is a requirement under the statute. Now, Your Honor asked about these different factual allegations, whether the Halls check was insufficient and so forth. Our submission is that even if all those were true, just as a logical matter, if he is not subjectively aware of a substantial risk that there's live ammunition in that gun, and they don't allege he is, he cannot satisfy that element of the offense, because the only way that gun can kill somebody is if there's live ammunition in it. They can allege whatever else they want about he violated the SAD guidelines or he did this and that, but if they can't allege that he has plausibly that he was subjectively aware of a substantial risk that the firearm contained live ammunition, they simply cannot meet the elements of the offense. I know Your Honor asked about Moreta. That case in the quote Your Honor presented says generally intent is a question for the jury, and we have no dispute with that. I mean, in most cases, recklessness, knowledge, intent, that's going to go to the jury unquestionably. But where the state cannot allege, does not even purport to be able to prove an essential link, namely that the defendant understood that his actions had a substantial risk of hurting somebody else, it should not go to the jury. The Rule 5601D standard is there because the judge is a critical gateway on allowing defendants to be prosecuted for things that are not crimes. What they have alleged here is not a crime. You cannot be guilty of involuntary manslaughter if you had no awareness of a substantial risk that what you were doing could harm people. And in the case of a gun, in this very unusual case of a prop on a movie set, where everyone, according to the state, believed it was empty, you cannot satisfy the mens rea for involuntary manslaughter.
Again, the analogy here would be that you can't convict someone of drunk driving, homicide, involuntary manslaughter for driving drunk and running granny over in the crosswalk, unless you had substantial knowledge that there would be a granny in the crosswalk when you blew through the intersection. Not the strongest of arguments.